An occupation is defined under international law in Article 42 of the Hague Regulations, which states that territory is considered occupied when it is actually placed under the authority of the hostile army. The occupation extends only to the territory where such authority has been established and can be exercised. This definition is contingent upon the lack of consent by the host state and its ability to exercise a sufficient amount of control over the territory. Therefore, it will not exist where a state has consented to the foreign army or if consent has been given but then revoked. An occupation will exist when this consent has been revoked. The law of occupation seeks to balance three often conflicting and competing interests: that of the ousted sovereign, the occupying power, and the occupied population. This is seen in almost every provision of the law which applies to this unique situation. Article 43, for instance, says that the occupant is to take all measures in his power to restore and ensure as far as possible public order and safety while respecting, unless absolutely prevented, the laws in force in the country. This emphasizes the temporary nature of an occupation and signifies the conservationist character of the law, in that as sovereign title has not been passed on to the occupant, it cannot take action which would be the prerogative of a sovereign state. That is, it must just restore and ensure public order and safety and cannot amend the laws in force in the country. The occupying power holds territory in trust for the ousted sovereign. It is therefore hostile to the notion that the occupying power can alter the legal status of the territory beyond what is required. The occupying power's obligations include ensuring the availability of food and medical supplies, preventing the looting, plundering, and exploitation of natural resources, and respecting a protective person's honor, their family rights, religious convictions and practices, and manners and customs.